Judgment in the appeal, Haile and the London Borough of Waltham Forest.
Lord Reed will give the judgment of the court.
This appeal concerns a young woman, Mrs Haile, who is homeless. She has a priority need for housing as she is the mother of a young child. Her local authority are under a statutory duty to secure accommodation for her unless they are satisfied that she became homeless intentionally. The authority decided in 2013 that she did become homeless intentionally because in 2011 she voluntarily left a hostel for single women in which she was then living and in which she could have remained for longer. The authority accepted that if she had not left the hostel at that time, she would have had to leave it a few months later in any event, as she was expecting her baby and children could not stay in the hostel. But the authority regarded that as irrelevant. In supporting that decision, the authority have relied upon the decision of the House of Lords in a case decided in 1981, Dinn and Wandsworth, which concerned another applicant for assistance who had left accommodation voluntarily. It was accepted that if he had not done so, he would probably have been evicted some months later for non-payment of rent. The authority argue that the present case is essentially the same. That argument was accepted by the judge in the county court and by the Court of Appeal. Mrs Haile now appeals to the Supreme Court. By a majority, the Supreme Court allows the appeal. The majority of the court consider that this case is materially different from the case of Dinn. It was accepted in that case that in order for a person to have become homeless intentionally, his current state of homelessness must have been caused by an earlier deliberate act or omission, as a result of which he ceased to occupy accommodation which was available to him and which it would have been reasonable for him to continue to occupy. In the case of Mr. Dinn, that test was satisfied. He had voluntarily left accommodation which he could have continued to occupy, and nothing relevant had happened afterwards to break the link between that action and his homelessness. Although he might have been evicted for non-payment of rent if he had not left the accommodation of his own volition, the House of Lords considered that authorities did not have to investigate hypothetical possibilities. The present case appears to the majority of the court to be different. It is accepted that Mrs Haile voluntarily left the hostel at a time when she could reasonably have stayed there. But then she had a baby. She could not have remained in the hostel after the baby was born. So she would have been homeless because of the birth of a baby, even if she had not left the hostel when she did. In those circumstances, it cannot be said that her homelessness now is the result of her leaving the hostel before she had to. Her doing that has made no difference to her present position. This conclusion is consistent with the purpose of the legislation concerning intentional homelessness. It is designed to prevent queue jumping by persons who seek to bypass the waiting list for housing by deliberately making themselves homeless and so obtaining preferential treatment which they would not otherwise have received. But Mrs Haile has not jumped any queue as a result of leaving the hostel when she did. If she had not left the hostel then, but had waited until the baby was born and she had to leave, she would have been entitled to no more and no less than the assistance which she now seeks, and which the court holds that she is entitled to receive.
The court's adjourned.